Welcome back to Kapowich on Real Estate. This is a program dedicated to consumer protection within the residential real estate arena. We were pleased to have back in the studio CEO of the MLS, the local MLS, Jim Harrison, and Tony Ventura, real estate attorney. We're speaking about off-MLS, pocket listings, whisper listings. And Jim, can you describe for the audience what a whisper listing, pocket listing is all about?
So that's a listing, that is a real listing, but it's just not on the market in the same way that properties are normally marketed, so that they're in the multiple listing service, advertised on the internet, syndicated to different places, and show up on people's websites. So whisper listings, pocket listings, off-market listings are properties that are being sold without the support of the rest of the real estate community.
Okay. Real estate attorney Tony Ventura. Anthony Ventura, you grew up in a real estate office.
Yes.
Right? You have a lot of relatives that are realtors?
Yes, I do.
Okay. We won't hold that against you.
Fair enough.
So when would be an appropriate time to have an off-MLS listing? When a seller's selling their home, you know, for instance, a sick child or it's a judge or prosecutor, when's it legitimate?
There are very narrow categories, I think, where people can make informed decisions and consent to have it off the market. Medical conditions come to mind, people with immune deficiencies or can't have bacteria or germs in the house. Very elderly people that don't want to be bothered or can't have, don't want people in their house.
Correct.
And then when houses were being foreclosed upon more prevalently, you saw it trying to shield it from neighbors or family or friends, those types of things.
Mm-hmm. Now, back to Jim here, in terms of how it might erode the actual numbers that we're using for the real estate community. Can you talk to that issue?
Well, so if a property is transacted outside of the MLS, then we don't see the data. We don't have the historical data. We don't have data to use for CMAs, for valuations. We have a scenario there where we're just not where the community doesn't have access to it, or for the data for future valuation of properties that they get listed in the future for this one as well.
Okay. Now I made a little homemade chart there for you. In 2008 we had the peak of the inventory. What was the number on the inventory of your MLS?
In 2008 we had 18,000 active listings at that point in time.
Wow.
And not hardly any off-MLS transactions that we were aware of.
That's amazing.
And then it did kind of, in 2013 we were down to 6,000 to 8,000 active listings in 5 counties, and we saw off-MLS business practices actually skyrocket at that point in time.
Skyrocket. So in other words, it goes from a buyer's market to a seller's market, and suddenly these issues of being off-MLS suddenly appear.
Yes.
Okay. Now, Tony, let's go back to you. You defend real estate agents that get in trouble.
Yes, and also represent people in cases against real estate agents.
Right, so buyers, sellers, agents, agencies. When a seller, how does a seller find out that perhaps when a seller sells their home off MLS, a neighbor might tell them, hey, you undersold it, or they leave town and they hear later that the same model showed up and sold for 100,000 more?
Yeah, my experience is that sometimes it's neighbors, sometimes it's elderly people that sell their houses, and their kids or grandkids come through and see the papers and find out what they sold it for, and tell them that it's worth a lot less. And then the other way you see it is a lot of times people move out of the area, and with sites like Zillow, they're constantly looking at the Zestimate on the house they sold to see, if it's gone up, if it's gone down, and all of a sudden they'll see another sale on the sheet and say, hey, why is that? And then they look a little closer and then they find out they sold it for significantly less.
Now, in terms of representing firms, what is the policy you would recommend for a real estate firm in terms of marketing the property?
I think the biggest issue comes down to whether the seller has actual informed consent or not. Too many times the agent comes in with a package of materials and says sign through all this stuff, and they don't really understand what they're signing because people aren't taking the time to read through it all. So I think if somebody went through and actually explained the pros and the cons to being off market, including one of the negatives being you may earn significantly less on your sales price, then people would make more of an informed decision. I think too often what we see is you have a house that's, say, truly worth $1 million, and the agent comes in and says, you know, I think it's worth 800,000, but I can probably sell it off market for 850. And then they sell it for 850, and the seller's happy because they got 50,000
Right.
more than it's worth.
Sure.
But the reality was it was always worth $1 million.
There you go. Jim, we talked about, you started a task force. When was the task force started?
It was 2012.
2012, okay.
And we interviewed realtors that were practicing selling properties off the MLS and trying to understand why, because it was growing, it was becoming really obvious. And as we interviewed them, they had reasons why. They didn't want the days on market to count yet. They didn't, they said their sellers didn't want it on the internet yet. Maybe it just wasn't ready to sell. But there were a variety of reasons why people were withholding it from the MLS.
Okay. Now, in all fairness, I was on that task force. I sat in on those conference calls and all that brainstorming. And you came out with a coming soon.
So part of the recommendations from the task force and the surveys and the town halls, something that came up over and over again was a coming soon status. So we have a coming soon status in our MLS so that other subscribers of our service can see what there's a contract on, but it's not active yet. We came up with rules based on the feedback we got from the realtors we spoke with.
Okay. So let's be clear. Tony, of course, you grew up in a real estate office. So for those that are concerned about privacy, they could still have it on the multiple listing service. And we have, what, 15,000 members, Jim?
We do, yes.
15,000 licensees that are members of the multiple listing service. But if they're concerned about privacy, they can have by appointment only?
Yes.
Okay. And they could limit the open houses?
Yes.
Same thing with pictures.
Yes. I mean, I think those limits apply in the vast majority of cases where the seller has some level of concern in terms of their privacy. I think there's other instances where there's a legitimate basis to keep it off market, but the difference is that basis may be 1 or 2%, as opposed to 19, 20, 25%.
That we're seeing now.
Right? I mean, because there's some people who have, you know, I'll give you an example that we had, which was an elderly couple wanted it completely silent and were willing to take less money because they didn't want their children to find out, because their children had already tried once to have them conserved as being mentally incompetent. So they didn't want anyone to know. That, you know, is something you really can't get around by putting it on the market in some form. But the point I want to make is that that's much more limited than what we've seen go on, which is people use off-MLS to double-end deals.
Okay, great. Now, Jim, you've had some wonderful statistics here. How do you compare the different counties?
So we service primarily 5 core counties, and we use the Realist Tax Service, a CoreLogic product, and we count how many transactions there were in every county and the median price for those transactions. And then we look at the transactions that happened in our MLS system, and we look for the delta. And we see the difference in the median prices and on the transaction activity as well.
Okay. Now, for instance, in the first quarter of 2013, 74% of the properties were on MLS.
Right.
Okay. And most recently here in the first quarter of 2016, we had 80%.
Correct.
On it. So that's 20% off MLS.
Yeah.
Okay. Now let's get into the delta in terms of the dollar amount, which is really something in terms of a percentage. Didn't you mention it last quarter of last year, the fourth quarter of 2015, it was 22%?
Right.
Sales price?
It's close to 30% in just Santa Clara County by itself. So
Wow.
properties that sell in the MLS, and keep in mind that we data share with other MLSs, and so there's 100,000 realtors with clients that see listings in our service. Plus they're syndicated to Zillow and Trulia, Realtor.com, franchisors' websites. So the exposure is massive when a property is listed in our system, which is probably
Wow.
one reason why it commands $200,000 more in sales price.
That's amazing. So let's inch up. So in other words, when a realtor licensee takes a listing for a seller, and they could put a sign on the lawn, an ad in the newspaper, they could put it on Craigslist, and once they put it on your multiple listing service, there's still another menu of items that they could do, right?
Exactly.
So how does that work?
Well, so we have a broker control center where the brokers go in and predetermine where we distribute their listings on their behalf.
Okay, so at point one, it could go to the 15,000 licensees.
Right.
The next step, don't they click the box and it could go to,
So we're
companies?
defaulted into virtual office websites and to IDX, and so those are websites that brokers and agents have, and so it's kind of defaulted that they're going to go to them unless they choose not to advertise their properties on the internet. But then they also can pick Realtor.com, Zillow, Trulia, Homes.com, and so the exposure, which is controlled by the broker and his agent, is pretty incredible, but it's all selectively controlled by the broker.
okay, now we've interviewed you before and you said automatically it could go up to 85 websites and soon will be in over 100 websites.
So we have we syndicate. We have one syndication tool called ListHub, which has about 300 sites in ListHub, and then we have 350 third-party vendors that get data from us.
Wow.
And so
Wow.
and that's grown over the last few years. But plus there's mobile sites and other sites that people are using for marketing properties.
Okay, Tony, I had, you're a very active speaker. You've spoken at our seminars and I've seen you at all the conventions. You had mentioned, and you grew up in a real estate office, is that nowadays the agents that get in trouble when you interview them or depose them, you find out that you add up their activity and it could be 8 to 12 hours, man hours.
Yes, and especially in some of these so certain cases we've had, you'll find that we found that an agent will double end a deal, $1 million, a $2 million deal, where there's very little work put into it at that point because they're not marketing it because it's off MLS.
Right.
They're not doing open houses. They're not making flyers, and they're handpicking the buyer. So it's just one offer and one contract, and then it's done. And it may be all cash with no contingencies, and they're ready to close in a week or 10 days or 15 days. And you start to divide that by amount of hours they put in, and you see people,
Right, yeah.
you see agents making $2,000-3,000 an hour.
Yeah. Now, in terms of the, of course, 25 years ago when I started, most 80% of the agents wanted to do a better job. It seems now it's flipped. 80% of the agents want to do a faster job with this World Wide Web and whatnot.
And that's one of the areas where I really have to defer to people like yourself who have their kind of feet on the ground, because as a litigation attorney, I only see a small percentage of the cases
Right.
where everything went sideways. The one thing I'd like to add, though, when we talk about the damage caused or the losses caused by off-MLS listings, is I think people tend to normally think in the mind of the seller losing money. But from a litigation perspective, a lot of the litigation we do, where how we measure what someone's damage is in a different case, is the diminution in value of the property, and that's based upon an appraisal. Well, when an appraiser comes in and has to admit that they don't know close to a third of the market and what it sold for, it affects those appraisals. For estate planning or estate sales, right, it affects the valuations that are given. When in divorce actions, when they're trying to value what the marriage settlement should be and who gets what out of the house, that's all affected when an appraiser can't look at what's on the MLS and what was closed and what it sold for.
Okay, that's a good point. That's what Jim speaks to about sharing that information in the big picture.
Well, because we're a sharing community. Our customers are all competitors, but in a multiple listing service, they've agreed to cooperate with each other and to share a commission. And so, marketing properties off the MLS goes against the very purpose of organized real estate.
And then in terms of appraisal values that for estate planning,
Well,
the impacts.
It hurts us all over the place because you don't just use historical data for appraisals, but also for CMAs, for listing presentations, and so big holes in the data makes it very, very difficult to actually support your clients and determine proper values for either setting the listing price or making an offer. So it hurts collaboration, it hurts cooperation, it breaks down trust between professionals, and it does impact their compensation as well.
Okay. Now, we were speaking in the green room about the double ending, dual agency. Can you speak to that, Tony, about what is a dual agency within an office?
Sure. So essentially what a dual agent is by definition is it means the same broker of record represented both the buyer and the seller. And that can happen at 3 different levels. You can have the same agent, Jane Smith, who represents both the buyer and the seller.
Right.
You can have an office that says has 30 agents, and Jane Smith represents one and Bob Martin represents another, where it's different agents but the same broker. Or with the larger brokerage companies like Coldwell Banker, you could have agents that are located 60, 80 miles apart who have never met each other,
Right.
which is much different than the same person who double ends and talks to both the buyer and the seller.
So that's still dual agency in terms of the law?
Yes, it's still dual agency in terms of the law, but in terms of how people feel cheated, they tend to feel
Yeah.
much more cheated if they find out it's the same agent on both sides or
Yeah.
the agent's friend on the other side.
And that was a number, I believe, the last time you checked, Jim, it was
It was-
19% of the
It's
time?
about 19% a couple of years ago, which was kind of at the peak of the off-market practices.
Okay. So 1/5 of the off-MLS was handled by the same agent,
Yeah.
which of course we didn't see in the Great Recession. Now in terms of dual agency, regardless of dual agency, Tony, whether it's off-MLS or not, isn't that for the sellers? What are the downsides for a seller when you have a dual agent?
Well, I usually start this with kind of an analogy, which is if somebody came into my office and said, I was rear-ended in a car crash and I've been out of work and I've lost a lot of money, can you represent me? And I said, yes. And the good news is I also represent the driver that hit you, so I can really do a good job and get this over with quickly.
Yeah.
Everyone would say, well, wait a second, you have a conflict of interest. How can you represent both the plaintiff and the defendant?
Right.
And in the real estate industry, we let that fiction exist and try to create these artificial walls, but the question is, how can you really do it? If you have a house that's listed at $1 million and as an agent, the seller will take $950,000, but you also represent the buyer and the buyer will pay $1,050,000 or $1,075,000, how do you reconcile all that information to advise people what offers they should make or what offers they should accept? Right. Because at the end of the day, the agent's a fiduciary for their client. Their job is to put their interest ahead of the agents, to put the client's interest first. And a lot of times the buyer or the seller is saying, well, what should I offer or what should I accept? And they're putting that decision and they're deferring to their agent, and their agent knows what both sides will do.
Now that's one thing about dual agency, is my understanding, which I learned from real estate attorneys like yourself, is that information, if you're a dual agent, I'm representing the buyer, I'm representing the seller, everything I'm told on one side has to go to the other and vice versa, with the exception of price. And that's the one thing you want is price advice.
And that's where it becomes really hard, because if you were on a different side of the transaction, right? If there were different agents involved and you represented a buyer and the house is listed at $1 million, you may tell your buyer, hey, let's go in at $850,000 and make them counter us and see how low we can get it. That's a harder conversation to have when you're the dual agent, you represent
Yeah.
the seller as well, and you have to go present that offer for $850,000 to the seller, and the seller's going to look at you and go, wait a second, you told me it's worth $1 million and now you want me to take $150,000 less? So there is a benefit, just like there's a benefit to having the whole market see the listing, there's a benefit to having two third-party agents that aren't related to each other or not in the same firm negotiate the deal.
Mm-hmm. Now that reminds me, Jim, you have an active complaint department, right?
I do.
Okay.
It's 4 people, full-time, plus we have automated systems looking for certain kinds of mistakes people make on listings. And most people don't make mistakes on purpose on their listings, so we give them a call or an email and ask them to correct it. But what we get turned into us a lot is our customers driving down the street and seeing a listing marked coming soon. And you're supposed to have an exclusion document on file with our MLS to not have it in the MLS yet, because we're a mandatory submission MLS. And so it's an automatic fine. If someone turns it in, we check our system. If we don't have an exclusion form, the agent gets a $500 fine for that.
$500. So that's similar to what we were just speaking about with Tony, is that perhaps that agent might be trying to generate phone calls and perhaps sell the house himself or herself.
Maybe.
Maybe.
Yeah.
Okay.
Maybe trying to get it ready to sell.
Maybe trying to just generate activity in the neighborhood. All right. And then, but if they don't have that exclusion, in the past it was a paper document that the seller would sign with a wet signature and they faxed it in.
Right.
Now it's electronic now?
It's electronic now, because we're getting 8,000 of those a year.
Wow.
In paper form. So we filled out we created a program where they just go register their exclusion forms, and then if we have to ask for one, we'll ask for one if something comes up. But they're now a form that's in the general listing presentation, so it's just one of those forms that in most cases get automatically signed like all the rest of them.
Okay, that's one thing Tony always speaks about at his seminars, is to set your client expectations, expectations for sellers. Now, when the agents are supposed to be taking a listing with the seller, you had originally the exclusion form to have it off the market while we got it the home ready. And then this off-MLS issue became a real problem, started to snowball. And then isn't it the California Association of Realtors picked up on our lead, your lead, and put it into their forms?
So we did a ton of analysis. We gave a lot of presentations at CAR meetings. We share our data with CAR. We were published in Realtor magazine. We spoke at the National Association of Realtors about this topic, and we really kind of raised attention nationwide to this issue. And now the forms have always been required, and they're still required to be on file. We just have them register the form in a short checklist system that we have today.
Okay, so we will be putting these slides on the air as the show airs. You could see the problem exist. You just got back from a conference, I believe, with 20 major MLSs. Right. And this problem is not exclusive to California.
No, this problem is in every major market in the country.
Wow.
And it's and it was MLS execs like myself that were surveyed to talk about what are we doing about it. And some of us have added coming soon statuses. Other of us have created, some rules around this. And they're all a little bit different because there is no standard. We're similar to 2 or 3 other MLSs because a couple of us were the first in the country to actually address this. And we built our rules around, what our customers told us were their reasons for not putting listings in the MLS. And seems to be working out well. I'm actually getting feedback from our subscribers now about how we can make the coming soon feature a little bit more interactive, because it's not searchable because it's not in the MLS yet. It's just a list. But they want it searchable, so we'll be working on that next. But all 20 are doing something about this. Everybody's addressing this, and just like us, we've seen a slight decline in the practice as inventory is starting to come back, and that's happening around the country too.
Okay, Tony, can you speak to about restitution or punishment or whatever terms you want to use when an agent is caught red-handed doing something like this? What are the different levels?
Sure. The primary claims that you would have would be for professional negligence and breach of fiduciary duty. That's the claim the seller would tend to make against the agent. If the seller's over 65, they could also make a financial elder abuse claim.
Absolutely.
Which has its own penalties and remedies to it as well. But usually what the damage is it's the diminution of value of the property, which is the difference between what the property was really worth and what the seller sold it for. So if it's sold for $200,000 less, then the damage is $200,000. And you can usually ask to make the agent give up their commission as well, so they shouldn't profit off of doing something that was negligent or a breach of their duty. The one other thing I wanted to mention is a very common complaint that we get from Off-MLS dealing with the real estate community is real estate agents, get word that a house is for sale and it's off the market, and they're trying to find out who the agent is, they're trying to submit an offer, and they can't because there's no one to go to. Or they submit an offer, but they find out that they didn't get it, even though they ended up offering $50,000 more.
Ouch.
And it's difficult because those buyers may just go look for a different property, but there's agents who are out there working hard who have buyers that are willing to pay more than houses are selling for and can't get offers presented.
Right. Now, in the example you just gave, so the seller could go after the agent for the $200,000 delta and the commission, brokerage fee, and get reimbursed for attorney fees?
Typically, the standard listing agreement, like if you look at the CAR listing agreement, it has, I believe it has an attorney's fees provision in it.
Okay.
But that could change, that could vary by broker. So certain brokers take that out so that there is no recovery of attorney's fees. Some brokers take out the right to go to trial and they make you go to binding arbitration. So the listing agreement could, vary what the seller's rights are in certain situations.
And then if it is, the couple is over 65, that is perhaps a criminal case as well?
Yes, I mean, if it's egregious enough, you can go to the police or the district attorney. My experience, it's been difficult to get traction that way. But one of the benefits of a civil elder abuse claim is it's basically strict liability. If the person's over 65 and they receive less than fair value, they win on their claim.
Got it. In closing here, Jim, you mentioned you went to a meeting recently and you were speaking about the MLS, and there was buyers, agents who had buyers that would have bought properties or paid more than were closing.
That's and I hear that frequently. And this was in a community where I was speaking at a broker tour, and the homes are more expensive in that part of Silicon Valley than other parts, and there were over and over again agents came up to me going, I have buyers looking for $3-4 million homes, and they're being sold off the MLS, and we never had a chance to bid on them. And at the time, it was a bidding war for listings.
And that's a case where some of the buyers might knock on the door during an escrow or write a letter afterwards saying my buyer would have paid more, or the buyer themselves.
I mean, I think at the end of the day, that's why you see values less for things that are off the market. The fewer number of potential buyers looking at something tends to drive down what the price is going to be.
Got it. Tony, thanks again for coming out.
Thank you.
Tony Ventura. Jim, can you stick around for another show?
Sure, no problem.
Beautiful. Thanks again for watching Kapowich on Real Estate. This is a program dedicated to consumer protection within the residential real estate arena. We will see you next week. Thanks again.